Let's now discuss the sources of obligation. Civil code or in special law are demandable. Also, what are example Internal Revenue Code of the Philippines? Contracts has been defined in the Civil Code of the Philippines. The contract, as then the other party can go to the Court of Justice. Contracts, these are negotiable just to and solution. And then, you have PT. Okay, so from that example, guys, so your neighbor has a shared thought that you have given her the right to receive it. What we need to do, you have USD property versus Canada obligation to return the revised penal law and the other law. The civil indemnity is an example of the law said you need to pay a minimum other is fault. There is fault or negligence on the part of the company, terminal negligence on the part of the driver or the bus. So what is the distinction between CULPA contractual and CULPA passenger of the bus that has been provided with? So these are the 5 sources. Let's discuss the second part of the general provisions of the law on obligation. Let's now discuss the sources of obligations. Under the Civil Code of the Philippines, there are 5 sources of obligations. These are law, contracts, quasi-contracts, quasi-delicts, and delicts. So when we talk about law as a source of obligation, the obligation arising from law is not presumed, which simply means that if it is not provided by law that you have such an obligation, you don't have such an obligation. Only those expressly determined in the Civil Code or in special law are demandable. So what are examples of these obligations that are arising from law? These, number 1, your obligation to pay taxes is stated in the Constitution and also in the National Internal Revenue Code of the Philippines. Okay? The obligation of the spouses to support each other is provided under Article 291 of the Civil Code of the Philippines. The obligation of employers under the Workmen's Compensation Act is another example of a law of an obligation that arises from law, and obligations of the owners of the dominant and servient estates in legal easements is provided under the Civil Code of the Philippines. So these are common examples of obligations arising from law. So let's talk about obligations arising from contracts. When we talk about contracts, contracts has been defined in the Civil Code of the Philippines as a meeting of minds between persons whereby one binds himself with respect to another to give something or to render some service. Okay. As far as the contracting parties are concerned, contracts has the force of law, which simply means that between the contracting parties it is considered to be a law. So if one of the parties will not perform his obligations under the contract, then the other party can go to the Court of Justice to compel the other party to perform his obligation because the contract has the force of law. So let's now go to quasi-contracts, the third source of obligations. Quasi-contracts, contracts that are based on the basic principle of law that no one shall unjustly enrich himself at the expense of others. So there are 2 kinds of quasi-contracts. These are negotiarum gestu and solutio indebiti. So when we talk about negotiarum gestu, it's a voluntary administration of the property, business, or affairs of another without his consent or authority. So, let's say, for example, guys, your neighbor has already been in the US for 20 years. So, he left his property here and it is not maintained. The house is already dilapidated, roofs are already rusted, and the ceiling are already coming down, paint's already uh, pale and out of the wall, and grounds are already overtaken by wild grass and bushes. So you take a look at the property of your neighbor, and then you have pity, you have mercy as a good neighbor. You have the property maintained. So you have the roofs replaced and painted. You have the ceiling repaired. You have the walls painted, and the grounds cleaned and landscaped. So after 20 years in the US, your neighbor came back. So, and your neighbor is surprised that the property is well maintained. Does your neighbor has the obligation to reimburse you of whatever expenses you have incurred? The answer is yes, but only to the extent of the necessary and useful expenses, but not with the ornamental expenses. Okay, so from that example, guys, the replacement of the roof, the painting of the roof are what we call necessary expenses. The repairs of the ceiling and the repairs of the ceiling is considered to be necessary expenses. The repainting of the entire wall of the house is considered to be a useful expense. But the landscaping expense of the ground is considered to be an ornamental expense. So your neighbor has no obligation to pay you the cost of landscaping the ground because it's already an ornamental expense. All right. So let's go to solution indemnity. Solution indemnity refers to the payment by mistake of an obligation which was not due when paid. So it creates the obligation to return the payment. So let's say, for example, you went to the grocery store, you bought your grocery. When you are in the counter, you give the cashier a 200 peso bill because the total amount of the grocery is 150 pesos. But the cashier thought that you have given her a 1,000 peso bill, so she give you 850 pesos as a change. Do you have the obligation to return whatever is the excess? The answer is yes. This falls within quasi-contract, specifically under solution indemnity. When you receive something, when you don't have the right to receive it, you have the obligation to return. This is also present in UST cooperatives versus City of Manila. When UST cooperative has been paying property taxes when under the provisions of the law, it is exempted from paying taxes. Upon realizing that UST cooperative is exempted from paying the taxes, UST demanded for the reimbursement of whatever is paid or the return of whatever is paid. So is the City of Manila has the obligation to return whatever is paid by UST cooperative? The answer is yes, because this falls within quasi-contracts, particularly under solution indemnity. The next thing that we will discuss, guys, are delicts. Delicts are crimes committed by a person. So these are acts or omissions punished by law. Those crimes enumerated under revised penal laws and other special laws. Example of this is a person convicted of a crime of rape has the civil liability to indemnify the victim and a criminal liability penalized by imprisonment. So, if you are proven to be guilty of a crime, you have two penalties there. One is the penalty to pay civil indemnity, and the other one is a penalty to be imprisoned as punishment for the crimes committed. So the civil indemnity is an example of obligation arising from delicts. Let's say, for example, if you kill somebody, the law said you need to pay a minimum of 50,000 pesos and you will be imprisoned as a penalty for committing the crime. So the obligation to pay 50,000 pesos for the loss of life is an obligation arising from crimes. Okay. The last one is quasi-delict or tort or CULPA AQUILLINA. So, these are acts or omissions that cause damage to another. There is no fault or negligence. There is fault or negligence. There is no pre-existing contractual relations between the parties. Let's say, for example, A is a passenger in a particular bus transport when it collided with another passenger van. Okay. The obligation arising from this case are as follows. Okay. CULPA criminal or criminal negligence for the drivers of both the bus and the passenger van. Whoever is at fault. Okay. CULPA contractual for the bus company. Okay. Because A is a passenger of the bus company. CULPA AQUILLINA on the part of the van transport because A is not a passenger of the van. So, in other words, there are three kinds of negligence. Okay? So, quasi-delict or CULPA AQUILLINA is one of those negligence. When we talk about quasi-delict or civil negligence, that is also otherwise known as CULPA AQUILLINA. The other is criminal negligence, and the other one is contractual negligence. Okay? So, when we talk about, in this case, contractual negligence on the part of the bus company, criminal negligence on the part of the driver of both the bus and the van, and CULPA AQUILLINA or civil negligence on the part of the van because A is a passenger of the bus. So there is no pre-existing contractual obligation between A and the van. Okay? So what is the distinction between CULPA contractual and CULPA AQUILLINA is that when there is a pre-existing contractual obligation, such as when you are a passenger of the bus and the bus meets an accident, the liability or the obligation of the bus arises from CULPA contractual or contractual negligence, or basically from the five sources of the obligations, the obligation arises from contracts. But when you are a passenger of the bus and it collided with a passenger van, the van company has the obligation arising from CULPA AQUILLINA or civil negligence because there is no pre-existing contractual obligation between the passenger of the bus and that of the van. Alright, guys. So these are the five sources of the obligation. See you on the next video, guys.